Hello everyone, my name is Lawrence and today I'll be doing my resubmission to explain the facts and holdings for the case Fairfax Media Publications and Reed International Books Australia. According to the facts, Fairfax publishes the Australian Financial Review, AFR. Reed, trading as LexisNexis Australia, delivers a subscription service known as ABIX. ABIX is an electronic newsletter which summarizes a variety of newspapers and magazines' articles, including AFR articles. The summary does not reproduce the advertisement, photographs, or quotes used in the articles. This means the argument is solely over words. Fairfax sued Reed, claiming it had infringed its original literary works that was protected by copyright in 10 selected articles, including their headlines. The claim involved 4 different types of copyright works contained in each edition of the AFR. This includes each individual headline in an AFR edition, each article including its headline and byline written journalists employed by Fairfax and published in an AFR edition, the compilation consisting of all of the articles including their headlines and bylines in an AFR edition, and each entire edition of the AFR. Here Fairfax sought a declaration that Reed had infringed its copyright in original literary works by providing its subscribers with abstracts of AFR articles, and an injunction restraining future infringement. The court held that the copyright constitutes in original literary works, and the headline in this case were not literary works. Justice Bennett stated that headlines generally are like titles, simply too insubstantial and too short to qualify for copyright protection as literary works. They act as a way of identifying the works, and extending copyright to them would prevent others from even referring to the work without infringing copyright. That would clearly be untenable. However, this does not mean that theoretically a headline or title could never ever rise to a level of being an original literary work, as Justice Bennett acknowledged. But it does not mean that the vast majority of them will not be. Moreover, Fairfax had argued that the article combination was a work of joint authorship that constitutes original literary work. It was established that generally a journalist prepared the article and Fairfax editors made some contributions, including the headline. Evidently, the author of the article and the author of the headline were two distinct people. The article referenced the journalist as the author, but did not refer the editors involved in its preparation. For the article to constitute a joint authorship for the purposes of the Act, both authors had to be identified. Hence, even if the combination of headline, byline, and article were a literary work, the headline would not be a substantial part because Justice Bennett found that they were not original. Without originality, the headlines cannot amount to a substantial part of the work. Further, even if Reed had infringed Fairfax copyright, it would have the defense of fair dealing available to it under the Copyright Act. A fair dealing with a literary work does not constitute an infringement of copyright if it is for the purpose of reporting news in a newspaper, magazine, or similar periodical and sufficient acknowledgement of the work is made. In conclusion, this decision has clarified the ability for information providers to create derivative services using others' work on the condition that the original source is correctly cited, and the abstract does not reproduce a substantial part of the original work. This decision should also be considered by those wishing to protect short commercials, bylines, and slogans. Given that brevity is common to such literary works, it could be argued that the court may take a similar view as to their copyright protection. Thank you.